Hello, welcome back to Business Law course. We are now on the discussion of the topic intellectual property law, and this is the third part. And in this part, we will discuss about copyright, especially about the definition and the concept of the copyright. Copyright is an intellectual property right that's recognized worldwide. The existence of copyright itself is constructed by international convention among many countries. Indonesia also, as the part of the international environment, they also protect the existence of copyright. The regulations of copyright in Indonesia have been developed from era to era, and actually copyright itself has been admitted since Indonesia was still under the colonialization that Netherlands at the time implemented the Other Sweat regulations about the protection for the author of a creation that now today we recognize as copyright. So the current regulation of the protection of copyright in Indonesia is Law number 28 2014. In that regulation we can find the definition in Article 1 that copyright means an exclusive right of the author vested automatically on the basis of declaratory principle after works are embodied in a tangible form without reducing by virtue of restriction in accordance with the provisions of laws and regulations. Well, that's literally. That's what the written regulation said. But the point is, when we talk about the copyright, try to take a look at the grammatical aspect here. So it consists of copy and rights. So simply we can consider copyright as a right to copy. So to copy a certain creation, you must have a right to do it. Though in the development, it's not only talking about the right to copy, but actually that's the principle. So copyright is the right to make a creations to be produced in a bigger amount of number. And one of the main aspects here is the existence of exclusive right in a copyright. Exclusive right here means that the one who owns the copyright is the party that has the authority upon the creation that protected by the copyright. The exclusive authority here means that the author here or the creator can use the creation by himself, or if he wants to let others to use it, he can give permission for that party. So if the one doesn't want to give the license to the others to use the creation, so the creation could only be used by the owner of the copyright. So that's why it's called exclusive. So he is the one who has the total authority upon the right. That's why it's called exclusive. There are two main things that we have to know in identifying a creation that protected by a copyright system. The first one is an idea. The second one is a real form of the idea. Copyright itself or the other intellectual property actually do not protect idea. The idea is only protected if the idea has been transformed into the real form. So if it is still only an idea in your mind, you cannot claim that this is my copyright. So you have to implement this idea into the real form, so you can say this is my copyright. For example, if I have made a certain notation of song in my mind, so I've imagined how would be the first verse would be, and also the refrain, the chorus of the song, but it's still only in my mind. I never make it in the real form, maybe in a recording, a product, or I share it in a certain platform like YouTube, for example. So there is no real form of the idea, so I cannot claim that someone is violated my copyright once someone is come up with the creation that, wow, I said that's my idea that's been in my mind before, and then that musician or that singer sing a song that actually exactly the same with the one that I concept in my mind. I cannot claim that, because to obtain the copyright it must be consist of an idea, and the idea has been transformed in a real form. That's also related to the words here, the basis of declaratory principle. Declaratory principle here means first to declare. So in copyright, registering the copyright is not mandatory, because as long as you can prove you are the first one who declared the creation, the law will protect you. It doesn't mean that you cannot register your creation. You can register it to gain the evidence, the written evidence, but actually the existence of the protection of the copyrights been initiated since you declare your creation. If I have a new song, then when I declare it to YouTube, or maybe I share it to my friends in social media, so that is my declaration of the creation. Since I declare it, if tomorrow or next month or next year another musician, another people claim a certain song, which actually the notation, the lyric is majority the same or similar with my creation, then I can say that they are violating my creation, my copyright, even though I do not register it, because I have declared it. So when someone come up with the idea, I already make the idea in a real form, I can say that's the violation of my creation. But if I have no real form of my idea, I will not be protected. So that is the declarative concept. So copyright is different with the other kind of intellectual property like patent or trademark, let's say. In patent or trademark, the system is constitutive, so you have to register, then your creation will be protected. If you already make a trademark but you never register it, and then tomorrow or next year a certain company make a new brand using a trademark that exactly the same with your trademark, so they are the one who lawfully own the trademark, because trademark has a different principle with a copyright. In copyright system you have to declare it, then you will be admitted as the owner. So now if you have any creation, if you have any idea, story in your mind, you have to create it in a real form. And if you read my book, I also say the real form here, the key point of understanding the real form here is that the creation should be able to be confirmed by other people that it's been declared. Because sometimes there are creations that not declared to public but already declared to a certain and limited parties. For example, a musician, sometimes they do not publish all of the songs they already made because some marketing and business consideration. Maybe they will wait to release the song until next year, but actually the song already recorded, and the recording company, the engineer already knows the song, but they are not allowed to open the information. So actually the copyright exists because it can be confirmed by the recording company, by the musician that involved in recording the music. So that would be the declaration for your creation. So even though the musician does not release the song yet, and then if next year another musician come up with the same song, the musician who already record the music can even submit a lawsuit upon the other musician that copied the creation, even though the creation is not published widely. So who can confirm it? Who can say it's been declared? The recording company or the engineer of the recording? In the recording process, there is an engineer who help you or the musician to record it. They can confirm it. They can declare it. As well as if you have an idea of novel or story, so it's been in your mind, but if you never make it in a real form, could be film, could be novel, could be book, so you cannot say this is my copyright, because the copyright expect idea and the real form of the idea, then you will be protected. So that would be the main part for us to try to understand the main concept, the definition of the copyright. So the copyright is declarative. Okay, so if you have creation, declare it. Do not just keep it, because one day when people come out with the same idea, you cannot claim it if you have no real form of the creation. So for the further discussion of this topic, I hope you also open the regulation during watching the continuation of this discussion at the following and coming videos. Look at the videos and also read the regulation. It would help you to understand about the topic better. Thank you.